tell us why it's important, specifically on CO2 pipelines, to protect against corrosion, please.
Well, in my opinion, there's no difference between a CO2 pipeline and another liquid pipeline as long as you dehydrate the CO stream before it's injected into the pipeline, which we will do at the capture facility.
In terms of dehydration, you're referring to specific equipment that'll perform that function, is that right?
Correct.
Now, in terms of water, it's true that Summit has been applying, at least in South Dakota, maybe in Iowa, for water permits, water that it needs to cool the CO2 down to 120 degrees prior to it entering into the pipeline, is that correct?
Yeah, so as you increase the pressure on the CO2 to reach the dense phase, that product heats up. And so we'll have a cooling system that circulates through that compression cycle that keeps the product cooler. And then we'll dehydrate that in the later stages of compression. We'll pull the water out of the stream in the later stages of compression.
And have you applied in Iowa for any such water permits, water usage permits?
Yes. So we're working with, we'll need the water supply at every plant. So we're working with individual plants. In the case of Homeland Energy in Iowa, we had to apply for a permit to drill our own water well, if I remember correctly. And so all that's, in Iowa anyway, that process is managed by the state's Office of Natural Resources, State's Department of Natural Resources.
And in terms of the usage amount in Iowa, do you have to get approval for a certain number of millions of gallons per year? How does it work in your understanding?
Again, it's generally my understanding is we have to stipulate to the agency what our water consumption need will be, and then they approve or they don't approve.
And is it true that you've been requesting consumption north of 20 million gallons per year at each facility?
Depends on the production volume at each facility. They'll range from 20 gallons a minute to 120 gallons a minute.
And would you agree with this new potential draw on water resources that could negatively impact surrounding water users who depend on that water for either industry or personally?
Well, again, the process is managed by the State Department of Natural Resources. So they should have a general understanding, actually a good understanding of what the water availability is, what the water consumption or water needs are, and what that long-term viability of the water sources are. So we depend on the Department of Natural Resources in Iowa and other states to confirm whether that water is available to us.
Are you aware if there is a draw on the available water resources, if anything about your permits that you receive in Iowa develops or lays out a hierarchy? For instance, residential users would have first priority and you would be lower on the totem pole, or what's your understanding about that?
I don't have an understanding. It is my understanding that our permit request for our Homeland Energy site has been approved. But then we'll abide whatever the conditions are that's imposed on us by the Department of Natural Resources, but I'm not familiar with what those may or may not be.
If a condition was that in dry years you would not be able to have the amount of water you have stated you need, would you agree you would have to shut down or significantly reduce your flow of CO2 into the pipeline?
Well, you were concerned about speculation earlier and projection, but there are other sources of water. So in the case of Homeland, our permit request was to drill a well on site, but there are other sources of water, and we'd have to make a business decision with the plant.
You were asked a question here on page 9 of 13. Has Summit applied, or does Summit intend to apply for any waivers from PHMSA? And the answer is no, but of course you could change your intention, or you could apply for waivers at any time if you saw fit, correct?
I assume so. The intent is still no.
Would you understand that, I mean, there's little value in what, as you sit here today, you intend. I mean, I didn't intend to get in an accident here, but it could have happened, and your intention doesn't prove or lock you into any long-term compliance. Do you understand that?
Well, that's true, but the board, I think, has the ability to impose whatever conditions on our permit if we were to receive one that they choose as, of value. So I'll leave it at their discretion of what conditions they want to place on a permit.
Relative to your real-time transient model leak detection system, what's the amount, what's the sensitivity of that leak detection? At what level can it no longer sense or detect leaks?
Well, those set points have not been finalized, but they're going to be very small. And just for everyone's understanding, so the real-time transient model is where we have the actual operation of the pipeline, and in parallel we have a simulated operation, hydraulic operation of the pipeline, so we can sense check the real-time operation with the simulated operation. And if we see a variance, and that may vary on like pipeline segment based on flow rate, if we see a pressure variance, then the control center can take action up to shutting in that line segment. But we will also have upstream and downstream pressure indicators around all block valves, and that pressure threshold or pressure variance threshold will be set. That tolerance will be very tight. And so if we see if those pressure indicators detect a variation in pressure above that set point, they will automatically close a valve.
Okay, but in terms of the sensitivity or the threshold of what could be escaping before it triggers valve closure, that level hasn't been set yet?
That has been set but not finalized. Happy to provide that when that's actually final. I will say we did complete the surge analysis, which is part of that. And under no circumstance will a surge pressure exceed our maximum operator pressure outside of normal operating boundaries. So that plays into what those set points would be, how quickly we close those valves.
Is your surge analysis, is that something that you've made an exhibit or made public in these proceedings?
No.
Is it something that you agree to release during these proceedings?
Objection.
State your objection.
It's a document that goes to PHMSA compliance, just restating the objection as to preemption on our PHMSA argument.
Okay. The board will rule on this issue, so sustain, please proceed.
Okay, so you're not going to send this, regardless of what you choose for sensitivity, there will still be a level of leak detection that is undetectable, where a slow leak could be occurring in the system, correct?
To use your word, theoretically. However, remember, our leak detection system is not only the only means to determine if there's a leak. If you've got a pinhole leak, you've got a flange leak, a very small leak, we'll do aerial surveillance every 2 weeks. And so that could detect it. We'll also periodically walk the line, not every foot of the line, but walk high consequence areas and inspect. And so if you see any type of frost buildup, then that's another indication where you may have a leak.
Well, you're not testifying, are you, that aerial surveillance is sufficient to determine whether there's pinhole leaks, are you?
I did not. I said it's not the pressure deviation is not the only means of sensing a leak.
Well, but your testimony says, quote, in the case of sudden changes in operating pressure, alarms will sound. And so they don't detect gradual changes in pressure, do they?
Correct. Depending on how you define gradual.
Well, you didn't define sudden, but I'm assuming sudden and gradual are two different things. Is that right?
If you have, in my experience, if you have any type of significant release or a breach, such as a third party hitting and striking the pipeline, that will be a sudden release. That will also trip your pressure threshold indicators.
Well, wouldn't that depend on the severity of the strike? Correct.
Yes.
And are you aware, or have you talked with anyone in the state of Iowa relative to how many third-party pipeline strikes on the linear pipeline infrastructure in Iowa happen on a monthly or annual basis?
Well, I do know that I have not. I mean, that's information that would be contained in the 811 system by and large. There are 47,000 plus miles of pipeline in this state, and third-party line strikes are the most common damage to a pipeline.
Okay. About the emergency response plan, I think we established you have not shared that with local responders, but you state here that you will coordinate with local emergency responders and authorities. And when do you intend to coordinate with them?
Well, I spoke about that this morning. So once we have permits in hand, and once we have right-of-way secured, then our emergency management team will sit down with local first responders, the emergency management professionals, and begin those conversations. And we're required to do a desktop review or drill prior to placing the pipeline in operation. And thereafter, we're required to repeat that annually. And we've agreed in certain instances, when requested, that we would actually do that more frequently. And the requests that we feel that to this point have been every 6 months. And that's due to primarily volunteer fire departments where I guess there's a higher turnover in a certain area.
All right, can we pull up, please, 569? Hello, 569. All right. In your testimony, sir, on page 13 of 13, direct testimony, you're asked the questions, will signage be installed to alert the public to the location of the pipeline? You say yes. Where'd it go? Sorry, thank you. Is it something like we've got here on the screen, exhibit 569, or what's your intention?
There are certain requirements, so we'll have to put the commodity, we'll have to put a contact number and other information so that if somebody actually has a concern that they know how to contact us, the operating company.
So the phone number that will be on there will be a direct dial to Summit, is that correct?
Yes.
And then does Summit have first responders of its own stationed throughout Iowa to respond, or do you rely exclusively on local and volunteer first responders for that reaction to a reported event?
No, our field personnel, those that are actually located in the field, will be trained on emergency response.
And will they be equipped with self-contained breathing apparatuses?
They will be equipped with the equipment necessary to respond to a release in that specific area.
Well, that's kind of vague. Is another way of saying that you haven't determined what type of equipment you'll supply those people with?
No, that's not.
Okay.
That's inaccurate. But it depends on where you are along the pipeline system and what the extent of a release could be, whether or not you would need self-contained breathing apparatus.
Well, you had, in your rebuttal, talked quite a bit about the PHMSA incident report in Satarsha, and you would agree there that the modeling Denbury had contracted to be done was insufficient to identify the risks. So are you relying on the modeling you've done to determine which areas you believe are of significant risks and those that aren't?
We are, but as I pointed out this morning, there are many differences. One being that we're actually incorporating 2D terrain-aided modeling. So not only will we identify how much product could be released, but also the physical pathways for that product to travel to what would be a high consequence area. And then also we're using Canary as our modeling software, which we feel is the best software available for a jet type release. So we feel it's the most accurate software available, and Canary is actually sense checked or calibrated against real atmospheric releases, test releases, versus FAST and some of the other models that are calibrated using releases that are contained in a testing environment indoors. These tests were conducted outdoors, simulating what we think is more likely to be a real-time release event.
And back to the signage here, you'll have a phone number, and that'll reach someone in Iowa or somewhere else if someone calls the number.
Now it will reach someone at our control center, which will be manned continuously.
And then what would the response time be from anyone at the control center to get to the location where the release or rupture is?
Well, someone at the control center will not be responding unless that release is near Ames, Iowa, but they will actually be the ones taking the action to shut in the system if they need to. And then the operations personnel, their response times depending on where they are and where the release is.
You had, well, let me ask you this. You're obviously not going to be placing any type of warning signs in the middle of fields, so these would be on the extreme boundaries of a property who has the proposed pipeline passing through. Is that right?
The requirement is line of sight, but to your point, yeah, there will be on all fence boundaries, roadsides. It is difficult in this part of the country when you have crops as tall as corn, and we don't want to put an obstruction in the middle of a field. So they'll typically be on fence lines and roadside.
And then if a farmer or someone in the field believes there is a incident, they'd have to get out of their combine, for instance, and then pick a direction to run towards the sign and then call the number. That's kind of how the process would work.
No, as I mentioned this morning, we are preparing tactical response plans, and those will be shared if they're interested. Those will be shared with the landowners. And then annually, we will provide public awareness information. So every landowner, whether the pipeline crosses that person or they're just in the adjacent area, they will get information provided in the mail or other means if they prefer, that will make sure that they have all the updated information, contact numbers, etc.
Okay. I'll offer Exhibit 569.
Are there objections?
No objection.
All right, as there are no objections, the board will admit the exhibit as Jorde Landowners Hearing Exhibit 569.
Thank you. Can we pull up 568, please? Now, sir, you talked previously about risk and probability and those kind of things, and based on your review and preparation to testify here today, would you agree that exposure to CO2 at and between 30,000 parts per million to 50,000 parts per million could lead to serious health risks?
Well, that's what your scale says. I do agree that NIOSH indicates that 40,000 parts per million is the immediate danger to life and health.
All right. And the 40,000 parts per million, is that the level that you utilized in the your dispersion modeling and risk analysis that you've done?
That's one. We use 15,000, 40,000, and 80,000. And as you probably know, at 40,000 parts per million, generally the guidance is that someone would have 15 minutes before they may start feeling any effects from a CO2 exposure. But we use 15,000 parts per million, and that's indoors, not in an atmospheric outdoor environment. At 15,000 parts per million, someone would have 8 hours. But we're using that broader boundary to identify how could affect areas in HCAs. So that's a more conservative approach.
And when we're talking about that kind of fictitious someone, it doesn't take into account sensitivities in terms of respiratory disease or pre-existing conditions. This assumes a healthy person. Is that correct?
Well, I think from the definition of NIOSH, generally or general health. I don't remember verbatim.
Okay. What about the effects on livestock? Do you have any analysis on the effects of livestock, given we're in Iowa and production, agriculture, and livestock is a big part of the economy?
Yeah, I don't.
Okay. And you said you tested out at, or at least modeled out at 80,000, and would you agree that between 70,000 to 100,000 parts per million exposure, that can go between nausea and consciousness and acute toxicity and death within 5 minutes?
I think that, well, I would suggest that we have another witness as an expert in this area, but I will say that this scale is, again, at least the one I'm familiar with, is specific to indoor environments and worker exposure. So we're using the more conservative measurements or thresholds, but if we have a release, it will be in an outdoor open air environment where typically the event lasts minutes.
And any type of overlay risk modeling using the potential dispersion distance that you have placed on any maps in South Dakota, did you use the 40,000 parts per million as your threshold?
We did. And I think it's important, Mr. Jorde, to point out that these thresholds, CO2 is mildly toxic and a simple asphyxiant like natural gas. The big difference is it's not ignitable. So the exposure limits are similar, but it's not ignitable.
It's not ignitable, but it's colorless, odorless, heavier than air, and would tend to sink to the level of where people are standing or sleeping. Is that correct?
Well, I would challenge your whether sleeping, but it can be heavier than air depending on the environmental conditions or atmospheric conditions, just like natural gas is heavier than air if it's got propane or heavier constituents in the stream.
And by bringing up natural gas now twice, are you trying to suggest here today that basically we shouldn't be any more concerned about CO2 risk than we are about natural gas?
I would suggest you be less concerned because it's not ignitable.
Does natural gas in terms of a release event tend to be able to travel a half mile or a mile from the release source?
You're asking me to speculate, but it depends on how many heavies are in the stream of natural gas. Depends on environmental conditions. I've witnessed propane releases where it stays close to the ground and travels a good distance.
And you would agree, based on that statement, that there's many factors that can contribute to, for instance, a CO2 plume and where it moves and at what concentration, correct?
I would, and we've modeled all those sensitivities.
Well, would you agree that the lower the wind speed, generally the higher the concentration of the plume because it's not being dispersed?
The lower the wind speed and the higher the humidity and the cooler the temperature.
Did you do any modeling at wind speeds less than 4 miles an hour?
Yes.
All right. Did you do any modeling of wind speeds at 40,000 parts per million at 0 miles an hour?
Again, I'm not going to get into the specifics of the modeling. Again, we've talked about whether we would provide that to the board. I will say that we've modeled all sensitivities around all atmospheric conditions, and we've modeled the 2D trainated flow, and we've done it for the entirety of the pipeline, just not high consequence areas, which is required by the regulation.
And when you say for the entirety of the pipeline, you would agree that a high consequence area, which is a term of art, a federally defined term, is one thing, but the individual family that may not be in a high consequence area per the federal government, it's still pretty important to them. Would you agree to be able to know the risks they're confronted?
Well, that's what I just said, Mr. Jorde. That's why we modeled it for the entirety of the pipeline. I'm glad you brought up the risk because, as Mr. Mulbauer can testify later in this proceeding, we've got a very robust quantitative risk analysis that takes into consideration all the potential releases conditions, not only for a guillotine failure, which is the regulatory requirement, but also what we think is the more common event, which would be a third-party strike or third-party damage, or we're calling it a mechanical failure. And so we've looked at all that. Then you look at design considerations, their integrity management program, and all those are inputs into the risk assessment. And then you can determine what the probability of a release, either in a high consequence area or outside of one, might be.
And unless all of that is produced and we call you back up to talk through it, the board really has nothing to rely upon in terms of evidence, do they?
Other than PHMSA typically does review them. They never, in my experience, have never asked for a model, but they review the inputs and the outputs, and they review the risk assessment and make sure that those seem like they fit together. And then they determine whether they think that you've adequately not only identified the risk, but mitigated the risk. And I think they've done a pretty good job because the reliability of pipelines in this country is very, very good.
But nothing PHMSA does, based on your answer you just gave, has anything to do with siting or locating the proposed hazardous pipeline, correct?
As I said this morning, Mr. Jorde, the dispersant model is not used for siting. It's used for determining risk in high consequence areas.
All right, I'll offer Exhibit 568.
Are there objections?
Will object. Lack of foundation. Hasn't been any testimony presented as to what this document is or where it came from.
Okay, thank you. Will reply.
Sure. He just verified the consequences shown based on the parts per million on this exhibit, so he verified that it's true and accurate insofar as the consequences associated with the exposure levels.
Okay, thank you. The board will admit Jorde landowner hearing Exhibit 568 and give it the weight due.
Thank you. All right, can we pull up, please, Exhibit 557, LO 557? Thank you, appreciate that. So, sir, right now we're looking at a map right off of your website. I believe it's current as of a couple weeks ago. What I'd like to ask you about is on the kind of western Iowa there in near Sac County. You see where the proposed pipeline drops due south and goes through several counties, including Shelby and Potawatomi, all the way down to Fremont. Do you see that?
Yes.
Do you have any idea of the length and miles of that segment from the yellow star at the top to that yellow star near Fremont, Page County?
I don't remember off the top of my head. No.
Would you agree it's well over 100 miles?
Again, I don't know, but that sounds reasonably accurate.
And you would agree that just kind of right out of the gate, we should kind of lop off that entire proposed route south of that area near Sac County, given that you'd only potentially be servicing a single ethanol plant in the southwestern corner of Iowa, correct?
Well, Mr. Peralta would be better suited to correct me here, but I believe there are 42 ethanol plants in this state. And so just because there's not an ethanol plant shown on this map doesn't mean there's not one in the vicinity. I can think of at least two that I'm aware of that we still hope will sign on with our project.
And again, I think hope is the key word. This application and your request is really founded more on hope and what the potential may possibly be as opposed to what actually is right now, correct?
Hope's not applicable to Green Plains, which is in Fremont, but I will say it doesn't matter if there are any additional plants on this line segment or not. It doesn't change what we've done with respect to engineering design, what we'll do in construction, what we've done in modeling and risk identification and risk assessment. So whether there's 3 plants connected to this pipeline segment or 1, doesn't change the calculus.
But in terms of the board's calculus and evaluating public convenience and necessity, you would agree that it's certainly not publicly convenient and necessary for the over 100 miles of landowners who are unfortunately located between those 2 points we've discussed to be subjected to forever perpetual easement simply for the benefit of that Fremont plant, right?
Well, I think that's a stronger argument than an oil pipeline that traverses the state and is not connected to any businesses in this state and the landowners that impacted.
Well, would you agree that the landowner should ultimately be their choice whether they want to accept certain risks or certain pipelines as opposed to others, or would you want to remove that choice from the landowner?
And Mr. Jorde, we don't establish the process in the state of Iowa. We're following the process that the Iowa Utility Board has in place.
I would offer 557, please.
Are there objections? Seeing none, the board will admit Jorde landowner hearing exhibit 557.
Thank you. You talk about some insurance. You would agree that $35 million in general liability insurance is insufficient to cover the entire duration of operations should your application be approved, right?
No.
Okay. Is that an aggregate policy or is that a per occurrence? How does that policy work?
So as we finalize, as we hopefully receive our permits and begin construction and operation, and prior to going into operation, then we'll work to finalize the structure of our liability insurance and have more clarity. But as you know, 479B requires $250,000. We've proved that we have a surety bond in that amount, and we've also agreed that we'll have a minimum liability policy of $35 million.
And you don't offer any insurance coverage for any damages that would occur to landowners' property outside the 50-foot permanent right-of-way, do you?
Any damages that are attributable to the operation or maintenance of our pipeline, we will cover.
and attributable being the key word after hiring lawyers and fighting back and forth and trying to defend themselves, and then maybe a judge or a jury determines attributable. Is that how that works?
Well, I think generally they would be very clear cut. If somebody struck the pipeline and we had a release, or we had to get in even without a release and repair the pipeline, then I think that's very clear cut that we would compensate the landowner for any damages and inconvenience.
And Mr. Rory will be the individual to speak more specifically to the easement and its terms. Is that correct?
That is correct.
And he is going to testify, correct?
That's correct.
All right. You go on to talk in your rebuttal testimony, page 3, you talk about Tarsha and draw some, I guess, some points here. I would offer Exhibit 565, which is the failure investigation report PHMSA's related to Tarsha.
No objections. Okay, hearing no objections. Was that 565? Yes, thank you. The board will admit Jorde landowners hearing Exhibit 565.
Thank you. And again, so as you cite on page 3 of your rebuttal testimony towards the bottom, that PHMSA at least found that Denbury on the Tarsha incident, their dispersion model underestimated the potential affected area, correct?
Correct.
All right. Now, you mentioned that you've utilized Canary. Is that, again, Mr. Locke that would be best suited to talk about Canary software?
Who?
Mr. Locke.
Oh, Mr. Luke? Yes.
Luke, sorry. I keep saying Locke. Mr. Luke, okay. Have you completed phase 2 or all phases of your geohazard surveys and analysis in Iowa?
Only phase 1 in Iowa.
And, okay, so because you haven't completed phase 2 geohazards, this board is without the requisite information to fully understand and appreciate the potential risks your current selected route may have in Iowa, correct?
No.
Do you think this board does not need to know the details of your phase 2 geohazard surveys to make a decision?
Well, I would assume that it would depend on what the phase 1 analysis produced. And Mr. Scrivener can talk in detail to that, but if in phase 1, if you identify areas such as landslides or other potential geohazard areas, then you would go evaluate in the field in phase 2. And then you would coordinate, if required, with the state geological office or geology office.
And when you, if you were to construct your proposed hazardous pipeline, would confront rocky areas, is it true you maintain the right to bury it at a lower depth than the 5 or 6 foot proposed?
No.
Okay. Do you think even in rocky terrain or difficult terrain that you still, based on the language in your easement, are required to go to a depth of 5 feet or more?
Objection.
State your objection.
Misstates the terms of the easement. I think it's been testified to that it's a 4 foot minimum depth.
Thank you. Mr. Jorde.
Okay, well, just change that out for 4 foot. I mean, are you saying that Summit has no wiggle room in the proposed easement to bury the pipeline at a level to the surface of less than 4 feet if it, in its sole capacity, determines the area to be rocky or otherwise difficult to locate a pipeline?
Yes, and we've already done the analysis on where we'll find or encounter rock and what we won't, and we have no concerns that there'll be areas that we can't trench or excavate through.
Why is it that in Iowa you're proposing a 4 foot minimum depth, but in South Dakota you're proposing a 6 foot minimum depth?
We're not blanketly proposing a 6 foot minimum depth in South Dakota, as we've stated all along, and as we've met with many landowners in Iowa and had these conversations, that PHMSA requires a minimum depth of 3 feet. We selected 4 feet as our minimum depth because of 90% of the land we cross is in agricultural use. And so if a landowner, because of tile or other concerns, would like the pipeline deeper, then we've agreed to go as deep as 6 foot top of pipe.
Is it true that you want to maintain a minimum of 12 inches or 1 foot separation from existing linear infrastructure that you might come into contact with should your pipeline be approved here?
Well, 12 inches is the standard, but we're trying to maintain 24 inches where possible.
And would that mean going below a tile line? Say if a tile line was at 5 foot, that would require you to go to 7 foot? Or could you do 3 foot and be above the existing tile line?
No, we will not bury it shallower than 3 foot top of pipe.
All right, so I'm sorry, go ahead.
I said 3 foot, 4 foot top of pipe.
Okay. All right. So if you come in contact with, for instance, a tile line that's at 4.5 feet, you wouldn't be able to maintain 12 inch, certainly not 24 inch, by being above and be within the 4 foot. So you would automatically go below in that instance, correct?
Yes.
Now, you state on page 6 of your rebuttal, 6 out of 6 here, that Summit has every reason to believe the North Dakota PSC will grant a permit based on the petition for reconsideration. What do you base that on?
Well, you read the order, Mr. Jorde, so you know they were very specific in what they felt were the technical deficiencies, and you were in those proceedings, so you know, for instance, geohazard analysis was done, even phase 2 level analysis was done, but that wasn't provided in time for cross-examination, apparently, and so we've already corrected those deficiencies and made sure all that is in the record. And what wasn't said in that order, but we believe to be true, was they generally didn't like the route on the north side of Bismarck. So even though the route where it was, there was no, the city of Bismarck was not even a could affect HCA. We've moved the route.
Well, okay. But that last statement that Bismarck wasn't even a could affect HCA, no one knows that because, again, in North Dakota, you refused to produce your dispersion modeling, correct?
It's not true. That dispersion output was produced in confidentiality, which was determined and agreed by the PSC.
Okay. And so you would agree it would be reasonable for this board, like North Dakota PSC, to not just have blinders on for HCAs, but deny this permit based upon location of your proposed route near communities or growing communities that may not be technically HCAs, correct?
No. And as we said, we discussed this morning, we've taken into account any readily available information, whether that's on their website, whether that's in, we've had over 2,000 communications with county officials involved in permitting in some capacity, county engineers, board supervisors, planning and zoning folks, etc. And over 400 of those have been presentations in person. So we've had a lot of opportunity, as have they, to provide information to us to make sure that we're taking into account where we can their planned economic development.
The last question on your rebuttal talks about EOR, which we touched on earlier, enhanced oil recovery, and your answer here says, quote, Summit does not intend to ship CO2 for use in EOR, period. Again, the intend word, and you realize that doesn't prevent you from changing your mind tomorrow, correct?
Mr. Jorde, in North Dakota, our sequestration site is at least 70 miles from the Williston area, which is oil and gas production area. There are no minerals in the area where we plan to sequester, which is why we've been able to acquire over 90% of that pore space, and why we're confident that the NDIC will give us a permit to inject, a Class 6 permit. So to utilize EOR in North Dakota, or CO2 for EOR in North Dakota, we'd have to construct a new pipeline north and west.
Approximately 70 miles, you said?
If I remember correctly.
So that doesn't seem real tricky given you're proposing a 2,000-mile pipeline right now, does it?
Well, again, it's not up to us. It's what our shippers and the sources of the CO2 want to do with their product. And in this case, the 12 partners that we have in Iowa want us to sequester that CO2 permanently so they can reduce their carbon intensity and gain access to low carbon fuel markets.
Well, right, and you go on to say at present, all parties intending to ship on Summit's pipeline system intend to permanently sequester the CO2 being shipped. But just to be clear, that could change at any moment, right?
As I said before, Mr. Jorde, for a common carrier system, if somebody has the ability to get CO2 on our pipeline system and has the ability to get it off of the system and they meet our quality specs and we have capacity, then that would be considered.
And in terms of this allegation of being a common carrier, is Mr. Paroli is better to deal with those factors, is that right?
Yes.
All right. I'll offer Exhibit 578, which is Summit's discovery responses to landowners data requests number 32 through 59.
No objection.
Seeing no objection, the board will admit Jorde landowner hearing exhibit 578.
All right, and I'm almost done. So throughout this process, we obtained records produced from a public records request between the governor's office here in Iowa, Ms. Reynolds, Governor Reynolds, and Mr. Rastetter, and persons interested with and supportive of Summit. Did you have a chance to review any of those records?
I did not.
And you would agree that there's a certain cloud over these proceedings related to the relationship of Mr. Rastetter with the Reynolds administration, Mr. Branstad, and others, such that many folks believe they're not getting a fair shake or fair proceeding. Are you aware of that sentiment?
Objection.
State your objection.
Calls for speculation, assumes facts, not in evidence.
Thank you. Mr. Jorde, go ahead and reword or move on.
Okay. Yeah, Mike, I'm not asking you to think about any other evidence. I'm just asking you as COO of this project, and here as the first witness for applicant, if you're aware of that thought process out there from people you're trying to obtain easements from and others, that the relationship between Summit and the state government is something to be concerned about and worrisome for those wanting to have a fair say in these proceedings.
Objection.
State your objection.
Same objection. Calls for speculation as to whether he's aware of others' thought processes.
Okay. You can answer if you'd like.
I would just say, Mr. Jorde, we're almost 2 years into this process, and so I think that the Iowa Utility Board has done a very good job of gathering information. I think the proceeding up to this point I've seen no impartiality. I mean, for the last 2 weeks, I think landowners, and they deserved it, had the right to spend as much time as they thought they needed to talk about the nuances of their property and the value of the property and why they didn't want a pipeline or why they were not in agreement with Summit at this point. So At this point, I would, regardless of what's said in the media or what others may say, I've seen no evidence that we're receiving special treatment from the Iowa Utility Board.
Well, what about on day one when you and your council were able to enter in secretly through the back door and everyone else had to wait in 100-degree long lines to be wanded down by your security forces?
Objection.
State your objection.
Argumentative, assumes facts, not evidence.
Okay. Sustained. Let's
All
move
right.
on.
Well, I will get the facts and evidence. True or false, on day one of these proceedings, you, Mr. Jimmy Powell, and your council were allowed to enter in through the back door of this very building, which is just to your left, while everyone else had to wait in 100-degree weather outside in lines to get security checked and wanded by your security force. True or false?
It's false. So we came in back door, so it's not to my left. So if that's the back door, that's the door. And if it's not my security force, they're Overwatch who are employed by us in another capacity, but the Iowa Utility Board dictated what type of security they wanted at this venue, and they're coordinating with the security folks themselves.
Okay, so it just so happens that your private security forces that accompany you to North Dakota, for instance, that are standing with surveying crews in South Dakota and are here today, just a coincidence that your security force is the force that is providing security of these proceedings?
That was the IUB's choice, and I wouldn't discredit the gentleman in the back that are with the sheriff's department and maybe the local police, because they've been here every day as well.
I think they're doing a fine job. So you did not, in fact, go through the security line the first day of these proceedings, did you?
I did not.
All right. Now, why don't we, I'll just go ahead and offer Exhibit 572 to show bias and admissions against interest.
Are there objections? Okay. Pull that up. Did you catch his response? Okay. Our staff does have the file located. They are pulling it up. It's just a large file.
I do have an objection, Your Honor.
I'm sorry, did you say you do or you don't?
I do.
Okay, go ahead.
Lack of foundation for this document. This witness specifically was asked if he'd reviewed any of these and said no. There's no basis for a foundation here.
Okay.
Well, I don't need to establish foundation through this witness. I mean, sir, do you dispute that Mr. Rastetter sent emails?
Mr. Jorde, we're just going to go ahead and refine it to his rebuttal, to his objection.
Okay. I thought that's what I was doing.
Sorry, I thought you were launching into questioning the witness. I apologize. Go ahead.
It may have been both. Yeah, so he doesn't have to have foundation for this exhibit to get in. Like the warning sign, he didn't create that. That's not a relevant objection to this exhibit.
Okay. The evidence will be admitted as Jorde landowner hearing Exhibit 572 and be given the weight due.
Thank you. Just give me one moment, please. Are you, sir, familiar with Project Tundra? Does that ring a bell to you at all?
It does.
And does Summit have any role or interest in that project at all?
We have a partnership with Nakota Energy to develop their sequestration sites, which are Tundra East and Tundra West.
And would you agree that that project is a step in the wrong direction and carries large risks for investors and its co-op members?
No, I wouldn't.
Okay. I would offer Exhibit 574.
Any objection?
Just a moment, I'm pulling it up.
Hope we get a minute.
We'll object to lack of foundation, as well as asking this witness to verify the accuracy of this document that he hasn't read, that also doesn't appear to have anything to do with the project before this board.
Well, he said this company is a part of this project, so he's very familiar with the project. It's no mystery there.
Well, we're not.
Okay, so hold on, we're just going to real quick. They are. The board will admit Jorde landowners hearing Exhibit 574 and give it the weight due.
Thank you. Then lastly, I would ask to be received into evidence the Autobahn Field Solutions, Summit Carbon Solutions, Dispersion Analysis, Midwest Carbon Express, dated August 31st, 2023.
Is there an exhibit number?
No, because you won't give it to us, but I have to offer the exhibit to make the record.
Well, without seeing the document, our objection is based on terms of preemption. The currently pending appeal before the board on the motion to compel, which I understand the board will be ruling on at some point.
Okay. Right now, we'll have to deny. We don't have anything to admit.
All right, that's fine. I can perhaps upload that. Well, here's my problem, and this is posed as a question. They've designated it as confidential. There was in the board order to make offers of proof. I'd like to offer it, but you're right, I haven't uploaded it because they say it's confidential, and I don't want to be in breach of confidentiality by the mere uploading it, even if I do confidential. So I guess I'm looking for some guidance to, is a party authorized to upload the exhibit with a confidential designation and then make an offer? If so, then I will do that at some point.
Okay. If you have them, you may distribute them to Summit's attorneys to determine whether or not we need to go in a confidential session to admit them. I'll also remind you that we have instructions on how to upload confidential documents and encourage you to check those out again.
Yep, and I don't intend to have to kick everyone out, and I am familiar that there is a method to do it. I just wanted to be sure that the very act of me attempting to upload them in a confidential fashion isn't going to get objections from counsel. I guess that's more what I'm looking for, and then I will follow that procedure. So I want some type of an assurance on that before I do it.
We do not have an objection to them being filed confidentially. I still don't know what they are. Is this something that was produced in another state pursuant to a confidentiality order in that other state?
Exactly, which is why I haven't done anything with it.
Until I have a look at that confidentiality agreement or order, I don't know what its restrictions are.
Okay, well, again, it's your client's document, so none of that matters if you just allow it to be uploaded. That's my point here.
Hold on, Mr. Long.
If the document is related to the subject matter of the order that we're presumably going to get soon from the board, I mean, perhaps we could just, the board mentioned that if those materials are required to be provided in discovery, witnesses could be recalled. I would suggest that we could deal with the materials in any necessary confidential session then.
That would be my preference.
Okay, so just to make sure I'm clear, I will then not be uploading them. We're basically waiting for the board's decision with the understanding we could recall Mr. Powell or whomever has the foundational knowledge of that exhibit. I just want to make sure we're all on the same page.
That will be an opportunity, yes.
All right, very good. Then that concludes my questioning. Thank you, sir.
Thank you. And Mr. Long, I believe you were next.
Thank you. Good afternoon, Mr. Powell.
Okay, Mr. Long.
So I want to follow up and clarify a couple of things that you were discussing with Mr. Jorde. Earlier you were discussing, well, I'll do this more systematically. Is it a fair restatement of your testimony earlier today that you consider the most probable cause of a release of gas from the line to be a third-party line strike, like an excavator?
Correct.
Thank you. You were discussing this earlier with Mr. Jorde, but I want to follow up to get some precision. You stated that in a discussion with Mr. Jorde that Summit would pay for damages resulting from, I can't remember the, attributable to operation of the pipeline. I want to follow up on what damages you meant would be included in that statement. If there were a third-party line strike, and let's assume that the excavator is 100% at fault, and let's use the word bystanders, by which I mean not necessarily landowners, but somebody close enough or with property like livestock close enough to have been harmed, would Summit pay those damages resulting from the release of gas, even if it was caused by a third-party excavator?
Yes.
Okay, thank you. I'd now like to introduce my hearing exhibit. I provided it electronically earlier. Oh, there it is.
Are there objections?
For Mr. Dublinsky and Mr. Leonard's reference, this is the response I just received to OCA data request 77.
No objection.
The evidence will be admitted as OCA Hearing Exhibit 1.
Thank you. Mr. Powell, I believe you just received a copy. This is a response that you listed as yourself as the author of to a data request sent by OCA. Do you recognize this document as that?
Yes.
Thank you. Following up on what we just discussed, you said that Summit would pay for damages to bystanders even if the release was caused by a third party. If you look at part B of your answer, am I correct in interpreting this that Summit is saying, even though it would pay those damages to bystanders, its liability insurance wouldn't be available? Is that correct?
That was not the intent.
Well, in your response to part A, is it fair to say that you're telling us that Summit doesn't really know the terms of what insurance it will have because it's going to have to negotiate it after construction?
Exactly, and that's why I say that we cannot confirm exclusions of limits of liability. I mean, just generally, Mr. Long, my philosophy and the philosophy of our management team is that if there's an incident associated with the pipeline, in your scenario, it's due to a third party, then we assume the liability with that, and we keep the landowner whole. And then if we have to deal with a third party on our own insurance carrier, we will do that. So if that's not the way you interpreted this, then I apologize, but that's our intent.
All right, and I want to clarify again because it's an important point to our office, but you said you would keep the landowner whole, but what if the injured party were not a landowner but someone adjacent to the line or even just a passerby?
Again, it's our pipeline we're operating, so we're obligated to remove the liability from at least the landowner in this case. And then if someone that's not associated with the landowner, you're saying, that's on the property?
Well, I mean, will you accept that if there were a release of gas, you wouldn't have to be on a property that's on the route to be affected and potentially injured? I mean, you could be at an adjacent property. Is that reasonable?
Correct. Not highly likely with a third-party line strike because we've modeled it, but let's say it could happen. So again, I confirm that we're liable for any damage that is a result of operating our pipeline, whether that damage is caused by a third party or by our own operation.
Okay, thank you. And as you've told us, Summit will not know the terms of his insurance until later in the process. Would Summit be willing to accept a requirement that it submit whatever insurance it obtains for approval by the board?
I think I can speak for our management team and say yes.
Thank you. Okay, the last thing I'm going to ask about, I don't have an exhibit, but do you recall in your direct testimony that you stated the purpose of your testimony was to explain why the company's proposal satisfies the requirements of Iowa Code 479B and to describe the benefits of the proposed line?
Yes.
Now, these questions are going to relate a little bit to a discussion you had earlier with Mr. Jorde. Would you agree that the benefits Summit claims for the line cannot be delivered if Summit is unable to deliver the CO2 to a sequestration site and to sequester it?
I would agree.
That's all my questions. Thank you.
Ms. Gruenhagen, I believe you're next.
Thank you. Good afternoon. My name is, I'm Chris Gruenhagen. I think we've met previously. I just quickly want to do a follow-up on something you were talking to Mr. Jorde about before lunch. You were discussing Mr. Peroli's rebuttal exhibit 1, the Iowa Renewable Fuels Association paper that was submitted. Do you remember that conversation?
I do.
In that conversation, you mentioned that there was a reduction in demand, that paper showed there was a reduction in demand of 75%. Didn't that paper lay out 4 different scenarios that could be taking place, and that the 75% was the worst case scenario presented in the paper?
That's true.
Thank you. So I want to visit with you a little bit about some statements that you've made during informational meetings, and we'll just kind of stay at a high level here. But at the informational meetings recently held in Floyd and Mitchell County, you stated that Summit would pay landowners for any crop damages sustained because of the pipeline. Is that correct?
Yes.
Does it matter when that crop yield loss damage occurs?
No.
So after 3 years, if a farmer informs Summit that they had crop yield reductions in the easement area, Summit would still pay for those crop damages accordingly?
Yes.
I have a hearing exhibit. I believe I did email this electronically as well, so. And since you have a copy, could you go ahead and read paragraph F in Summit's response?
Generally cost.
You can read it to yourself, sorry.
Oh, okay.
Well, it's being handed out. Does that paragraph F in Summit's data request response reflect how Summit is going to allow proof for that crop yield loss?
Yes.
Is there anything else that would need to be provided by a farmer who was experiencing crop yield loss in the easement area?
Again, I'm not a farmer, Gruenhagen, but okay. Any kind of verification that there's a yield deficiency would be sufficient.
And I know this was last fall, but did you see this data request response before it was provided?
I apologize. We see so many data requests that I can't keep track of them.
Okay. But paragraph F does reflect Summit's commitment on the paying for crop damages.
Yes, I mean, we spent a lot of time on this. I mean, obviously we work for an agricultural company who's very cognizant of this. And so just for context, the way we arrived at that is, we based it on the spot study that ISU did and in the yield efficiencies that some landowners experience from Dakota Access, and so we extrapolated that over what we thought would be 6 or 7 years, but have also said that after 3 years, or in perpetuity, if there's a deficiency, we'll take care of it.
Thank you. And has, looking at paragraph E, has Summit determined the process and who the contact person might be for claiming crop yield loss damages?
We have not. Mr. Roy will be involved in that. He will testify later in the proceeding.
Great, thank you. And at the information meetings in Floyd and Mitchell County, you also stated that Summit would pay landowners for damages to tile drainage systems that were sustained because of the pipeline. Do you recall that?
Yes.
Discussion? And is that an accurate summary of what you said?
It is. So obviously during construction, we'll repair temporary and cover temporary and permanent repairs. And at any time after the pipeline is placed in operation, during the life of the operation, if there's damage attributable to the construction, we'll cover it.
Thank you. And even if that drainage tile damage wasn't discovered until more than 5 years after the pipeline was installed, will Summit still pay for the damages then?
Yes.
Okay. Alternatively, would Summit also offer to fix the tile drainage system?
Yes. Or to pay their contractor a choice to repair.
Appreciate that, thank you. Will Summit also fix or pay for any damages the pipeline causes to terraces?
Yes.
And is that going to be a lifetime obligation for Summit?
Yes.
A similar question regarding conservation structures. Will Summit fix or pay for any damages the pipeline causes to conservation structures?
Yes, in the terms of their agreement around those.
Pardon me?
Depending on their agreement, you're talking about like good resource conservation areas?
No, conservation structures. So it would be like grass waterways, terraces, wasp,
Yes,
all those
sorry.
kinds of. That's okay.
Yes.
I appreciate you asking for clarification so that we're on the same page. Is this a commitment that someone is making for the life of the pipeline?
Yes.
You've been sitting in front of me here for the past. I have another hearing exhibit here. I just have 3, so.
That's okay. Mr. Long got some time back.
And so while we're waiting for the handout, if you want to review paragraphs C and E. Your Honor, while that's being handed out, can I offer into evidence IFBF hearing exhibit 1?
Are there any objections?
No objection.
Hearing none, the board will admit Iowa Farm Bureau Federation Hearing Exhibit 1.
Thank you. Thank you, Your Honor. Thank you. So have you had a chance to read through paragraph C?
I did, and I apologize, but I'm going to have to defer the responses to these to Mr. Roy. He's much better versed in how we're going to accomplish this.
Okay. On both, as well as the E as well.
Yes, I can tell you we'll keep the landowner whole, but he can tell you the specifics and mechanics around how we're going to do that.
Okay. So I'll just ask you, I guess, more of the more general statement. So when you say make the landowner whole, what do you mean by that?
Well, if they have an obligation that we interrupt with construction or installation of the pipeline, then we have to fulfill that obligation, generally. So if that's contractually, that's expense, whatever that might be, restoration, whatever that might be, then Mr. Roy, he'll be able to go into much more detail on how we'll do that.
But at a high level, if someone was out of compliance with their federal farm programs or their federal contracts, Summit would make them whole.
As long as that non-compliance is directly attributable to the pipeline, yes.
Thank you. I think also ask with my next hearing exhibit as well, deals kind of in this area, and so would you prefer that be directed to Mr. Rory as well?
I would. He'll give a much better answer and a more complete answer than I would. Okay.
I just have one additional line of questions as well. Dealing with negotiating easements, and I'm looking at a high level, not looking at the terms of the easement here. If the permit is granted, will Summit continue to negotiate easement terms and compensation with the landowners prior to filing for eminent domain?
Yes.
If the pipeline permit is granted, is Summit willing to offer at a minimum the same terms and conditions that has already been offered to those landowners?
Generally, yes. I hesitate because routing may have changed with the Exhibit H filing, and so we couldn't deviate from that unless the board gave us some discretion or flexibility there. But as far as compensation, within reason, yes.
So is Summit willing to purchase those voluntary easements for the same compensation as what Summit offered to the landowner prior to the start of this hearing?
Yes, qualifying what you just said, the start of the hearing, because some negotiations have been ongoing for a year, and then it goes up and goes down and goes. So, yeah, specific to the last offer, yes.
And if Summit was not given an opportunity to extend an offer to a landowner, will Summit agree to offer the formula price that was explained at the informational meetings as the lowest price that they would pay to the landowner?
Yes.
Can you explain the formula price?
Mr. Roy would be better suited
Okay.
to. He gets offended when I try to walk through terms and conditions and easement numbers.
Very good. You can do that. That's all the questions I have. Thank you.
Okay, thank you. I believe Mr. Whippel's next.
Thank you, Your Honor. Mr. Powell, I don't know if you can see my counties. I got 7 of them.
I know your counties very well, Mr. Whippel.
All right. Thank you, Mr. Powell. I want to return to the subject of the North Dakota permit. Will construction proceed in Iowa if the North Dakota Utilities Commission doesn't approve a permit?
No.
So will Summit accept a condition requiring approval in North Dakota and South Dakota for phase 1 of the project? Thank you.
And of course, we wouldn't construct that main line if we didn't think we could construct the laterals as well. So,
Condition in Iowa.
correct.
Will construction proceed in Iowa if Oliver County doesn't approve?
Although I think that's unlikely, we also have injection opportunities or sequestration site in Mercer County. So I would say if we don't have the ability to sequester in Mercer or Oliver counties or Tundra East or West, if we don't have access to any injection sites in North Dakota, I would accept that condition. I mean, I can't quote it off the top of my head. It's just various statistics. The most recent I read was 57%. So I'm not a farmer, so I'm typically looking for agricultural stats and updates, but I don't have a specific source.
And what I'm interested in probing for a minute with you is not just ethanol generally, but ethanol at the 12 or 13 summit partners specifically. What percentage of ethanol, of all the ethanol produced in Iowa, is produced at those 12 or 13 plants?
Mr. Whippel, Mr. Perley will be much better versed than I am, but I mean, if there are 42 plants, and I'm not sure that's the correct number, and we're contracted with 12 in this petition that we're discussing today, it would obviously be a fraction of the total volume.
Which is what I was driving at with my next question. You would agree that it's proportional to the proportion of ethanol produced at your ethanol partners?
Yes, and understanding that a plant is not a plant. So our Homeland Energy plant is one of the larger plants in our current contracted portfolio. So there are plants ranging from 50 million to 200 million gallons a year production. But generally, I think I would agree.
Sure, thank you. I want to ask a question about the 45Q tax credits. And not to turn you into a tax lawyer here, but you're generally familiar with them, correct?
Generally.
Isn't it true that they require construction to begin before 2026?
I believe that's correct.
And isn't it true that they can be claimed for 12 years?
I believe that's the current duration, yes.
So what I'm wondering is, why does Summit need permanent perpetual easements?
Well, we anticipate the life of the pipeline to extend well beyond 12 years, Mr. Whippel. And there are provisions in 479B that if we ceased operation of the pipeline, deactivated the pipeline, and took the pipeline out of service, that then after 5 years, then that easement reverts back to the landowner.
Sure, but what I'm wondering about is, you're making the case for public convenience and necessity based on the benefits of the ethanol plants, which is connected to the sequestration and which is driven by the federal credits. So is there public convenience and necessity when the tax credits go away?
Well, I would say that if the tax credits were to go away, and I being a taxpayer like you are, I don't know too many government programs that go away, but let's say this one does. We fully intend to be profitable after we generate enough income to pay for our cost of borrowing for construction. And the tax credits will not be our only source of income. So we fully anticipate being a viable business if the tax credits were to go away in 12 years.
But in both your testimony and in Mr. Paroli's, you're making the case for the benefits of the state of Iowa based on economic benefits and environmental benefits, which are closely connected to lowering carbon intensity, which are again closely connected to the tax credits. Wouldn't it make sense to time the easements to the tax credits?
Well, we're making the connection to the low carbon fuel markets, and that's reducing the plant's carbon intensity by reducing the CO2 from their capturing the CO2 from their process with or without a tax credit.
So you do not agree that the easements should be linked to the tax credit duration?
I do not.
I want to move on and talk a little bit more about emergency response. I want to follow up on something that Mr. Long asked you about, the third-party strikes. Given that there are frequent excavation in the road rights-of-way, shouldn't there be additional measures at road crossings to mitigate releases from strikes?
Yes.
Do you have an opinion on what those additional measures should be?
Well, it's multifaceted, but primarily it's depth of cover. So that's why we'll bore or drill all road crossings, and it'll be at a depth much greater than the minimum 4 foot for the other aspect or parts of the pipeline.
So you would be amenable to additional county terms and conditions on road crossings?
Well, we currently are. I mean, as long as they're reasonable and practical and within typical industry standard and practice. I mean, if the requirement is, and I'm throwing out a number, is 8 foot top of pipe, and that's pretty common, and depending on the risk and the type of roadway, obviously we're okay with that. But if they want us to put it 30 feet deep and there's no driver for that, then I'd want to have a discussion.
But just generally speaking, that be something you'd be willing to explore with county engineers?
Absolutely. And we have been with most.
Not advocating for 30 feet, by the way. Just
appreciate it. And don't advocate for pacing either, because it introduces risk. It doesn't help.
I'd also like to go back to something you were talking about with Mr. Jorde. He asked you about dispersion modeling a number of times, but at one point you said something to the effect that one of the reasons for not releasing the dispersion modeling was about safety and protecting the pipeline from people with criminal intent. Do you recall that part of your back and forth with Mr. Jorde?
There was a lot of back and forth. I do recall that, and this really aren't my words, it's been that, you know, that type of information should be protected. And there's a FOIA, can be a FOIA exemption regarding that type of information so that, again, like I said, we don't provide a blueprint. And I do have experience with that too, by the way, of individuals trying to sabotage pipeline and pipeline facility assets.
But they wouldn't have been county officials, would they?
No. I hope not. I don't remember, but I hope not.
A joke, but only a little. Do you view county officials the same way as the general public in terms of sharing with them the dispersion model?
I would rather not share the dispersion model itself with anybody because PHMSA doesn't even ask for the dispersion model. As far as the output, general conversations, yes, I have to consult with the management team and the attorneys, and there's a lot of other issues in play here, but I'm always happy to have a general conversation about the risk. And how deep we dive into that risk will be determined here fairly soon, I guess.
But isn't it true that PHMSA regulations require Summit to provide information to local emergency officials?
They do.
And that you have to inform local officials about your ability to respond to an emergency?
Yes.
And doesn't that include dispersion modeling?
That will include the output.
But your position is... No, go ahead, sorry.
No, honestly, that will include the output. Just for an instance, most emergency responders, to my knowledge, Rod Dillon will testify later in this proceeding, and he's an emergency response professional, former firefighter. They will use either, the weather-related dispersant model that they generate very quickly that's loosely accurate, depends on where it is and what the situation is. Or they'll use their guidebook, emergency response guidebook, for instance, for CO2, it's 330 feet. So they would automatically establish a boundary of 330 feet as the critical area. We'll share more information with them and say, in this area, that worst case scenario could be this, mechanical damage, third-party line strike could be Y, and here's how we should work together to establish a perimeter and establish a response plan.
But just to recall the maps that Mr. Jorde was showing earlier about Navigator and about the hazard zone, wouldn't you have to share essentially something like that in each county with those county officials about the assets in that county?
We would have to share, yes, so what they should expect for the extent of the atmospheric gas release. Is there any overland flow of vapor? And what the concentrations or expected concentrations could be in those areas. And then they would use that as a basis to formulate the plan. Whether or not it's the map as you saw up there, we'll have to determine. But it will be enough information, as I've done throughout my career, whether it's natural gas, refined products, or crude oil, or propane or ethane propane. You go through the same exercise with your local officials and first responders to make sure that they understand the risk and that they and you have the resources to address any type of release scenario.
Have you notified any city officials in any affected city that they're an HCA or an OPA?
I have not personally, as I mentioned before. I know we've had literally hundreds of interactions, so I can't tell you if that's the case. I have no issue doing that. We talked about our direct impact is 1.13 miles, and that's a handful of locations, and all but two are at ethanol plants in close proximity to. Those other two locations, be happy to talk to those officials about it.
Sorry, and I should have said the corporate you, not necessarily you personally, but somebody that's willing to notify officials in the cities that are HCAs or OPAs.
Yes. Again, subject to all of this legal discussion. I don't want to overstep my bounds there, but yes.
And are you willing to share the same information with the county officials in that county?
Yes. Within my legal constraints, if there are any.
Would that include information about where the critical valleys are?
Yeah, I mean, as I mentioned, we've done the overland flow analysis, and quite frankly, it's without getting too deep into this, it's very difficult to force the dispersed material to reach in a could affect area. So,
but isn't it true that there have been a number of counties that have asked for that information and have been asking for it for a year?
They've been asking. It's my understanding. Again, I'm involved on an occasion, but not with many of the counties directly. They're asking for the dispersant model. And look, if you want the dispersant model, that's something we're not willing to do. Something you can generate on your own. As Mr. Jorde's had his expert witness do that with ready available material. But as far as the output, that's a different ask, and I'm not aware that that's been the ask. It may have been. I'm just not aware of it. And it's also important to know the context of those discussions.
Well, I go back to,
because there were preemption issues ongoing, and so you're well aware of those, and so I'm always deferring to legal counsel on what we can and cannot discuss or share.
I'll put it to you this way. Would you be surprised to learn that the counties would like that information sooner rather than later?
And you're talking about your 7 counties.
Well, I only represent 7, but I haven't yet met a county that wouldn't like to know how to be prepared.
Oh, I agree with that. About being prepared. I'll just take your word for it. Say, no, I wouldn't be surprised.
It wasn't a trick question. I mean, ultimately, what we're going to struggle with is what you mentioned earlier about the specifics are important. Wind speed and location and the assumptions that you make. And you say, and I think it's not incorrect, that counties have some of those tools available to them to try to replicate that information. But they need to know actually what your response is going to be, don't they?
They do. And so without coming off as being flippant, Mr. Whippel, we're taking this in a phase process. We've introduced the project to these county officials. We've introduced it to the fire chiefs and the emergency management professionals. We have to get a permit to construct. And then from the time we get a permit to construct to actually when we finish construction and go into operation is going to be at least 18 months, depending again on when we receive the permit, when we can begin construction. And so we will ramp up that activity and make sure that before we place the project in operation, and PHMSA will require that we've satisfied our emergency response and emergency preparedness obligation, that we've had those detailed conversations with first responders in each county, that we understand what their resource constraints are, that we've augmented those to the extent practical. Am I going to buy electric fire trucks? No. Am I going to provide them with CO2 test apparatus? And am I going to provide them with, are there other things that we're thinking through now, like, electric UTVs? I mean, our team is thinking through that, and they'll collaborate with the first responders on what they may not. But we have committed to anything that they need that makes sense, that would be necessary for a CO2 response. Worst case scenario, we will provide. And we will do it in a timely fashion. So it's not last minute the day before we turn the valve or open the valve to start moving product. It's so they feel that they're trained and they're comfortable, because it doesn't do us any good to put a pipeline in operation. And in the unlikely event we had a release and it happened early into the life of the pipeline and they're not prepared, that doesn't help us either. So we want to make sure that we go about that in the right way. It's just a iterative process that we've begun, and we'll get in more, we'll develop in more, proceed in more earnestly over the next year.
So you say in your rebuttal testimony at page 4, line 18, that Summit has undertaken a more robust dispersion analysis than Denbury. How can counties know, how can the board know whether it is more robust if they can't compare?
Well, again, PHMSA has the obligation to ensure that they feel that what we've done is adequate. But I've already committed to the fact, and if the board compels us to turn it over, we will. Much like we have in South Dakota, North Dakota, they've got the same obligation for that question, is that we've already performed the overland flow component, which Denbury didn't do. And in this case, we are performing the geohazard analysis, which is best practice that Denbury didn't do. And we'll incorporate in our integrity management plan, which will be for the entirety of the pipeline, not just in the HCA. So we're doing things that I think are prudent for an operator that Denbury didn't do. And some of those, if not all, but some of those will be verified by PHMSA. So that's our integrity management plan, our emergency response plan, our public awareness plan, all those things.
I just have one more question on this topic, and I just want your opinion on it. But suppose the pipeline is built, it's already constructed, and you have provided the dispersion modeling and analysis to a county. Shared it with them, trained them, ready to go. Would it be inappropriate for county officials to use their zoning ordinances to prevent new development based on the dispersion model?
Objection.
State your objection.
I object to the extent it calls for a legal conclusion.
Okay. Mr. Whippel.
I don't believe it's asking for a legal conclusion. I believe it's asking whether he thinks county officials should consider that information in their decision-making process from a pipeline safety standpoint.
May answer if you know.
Well, I would just suggest that it may be prudent for planning and zoning officials to consider a host of things, including that. But as I'm sure you know, let's take Charles City, Iowa, for instance. So where we're planning to route the pipeline is an economic development area where there are 2 natural gas lines existing, and it hasn't impeded that development. So in that case, we're in an existing infrastructure corridor. But if it were there or somewhere else, and you can see all across this country, in Iowa, 47,000 miles of pipeline in Iowa, there's economic development in and around pipelines on a regular basis. But I do think it would be prudent for them to consider that as a factor like many other factors.
But they need to have it first, don't they?
Well, again, we can share information, but do they have the release plan for the natural gas? Let's talk about Charles City. Do they have the release plan or the dispersant analysis or the blast radius information for the 2 natural gas pipelines that run through that economic development area? My guess is they don't.
Yeah, I don't.
So how does the planning and zoning officials, how do they think through that process with those natural gas pipelines compared to a CO pipeline, which in my opinion is much less risky because it's an asphyxiant just like natural gas, but it's not ignitable. So they've got to reconcile themselves how they got to compare the risk profile of one versus the other, and they've considered both properly.
And I'll just suggest perhaps they should do it for both. But in either case, they would need the information, wouldn't you agree?
They would need some level of information, correct?
And I'm glad you brought up Charles City. I want to go back to that issue as the last kind of set of questions I have for you. But we went over the fact that you believe one of the reasons that North Dakota denied the permit was the proximity to the city of Bismarck, correct? That's a yes, correct?
Yes, sorry.
For the court reporter. How close was the proposed route to Bismarck?
It was further away than the pipeline is from Charles City. It's a much bigger area with a much broader economic development footprint.
Do you know approximately how far?
Not off the top of my head.
More than a mile?
Yes.
More than 2 miles?
Again, it's further than Charles City.
Well, in Charles City, it goes into city limits, I believe. Isn't that correct?
Again, it parallels 2 natural gas pipelines, and I believe, other than the Charles City Economic Development Group, every easement is signed along that route. So the landowners, and I think this is an important factor, the landowners, through their discussions with us and their own research, have felt that they had enough information to make a reasonable decision without the threat of
objection.
State your objection.
Lack of foundation as to what other landowners allegedly thought or how they felt.
Mr. Whippel?
I have no response to Mr. Jorde's objection, other than I was simply going to confirm with this witness that his response was a yes to my question, which is that it goes into city limits in Charles City.
Yes, it parallels those 2 natural gas pipelines.
Okay. Since he nodded his head, I like that recorded as a yes.
I said yes. Okay. It parallels 2 natural gas pipelines.
Okay.
Thank you, Mr. Chair. Do you know how close the proposed route comes to the city of Erling?
I do not.
Would you be surprised if I told you it was less than half a mile?
I do know the city of Erling is not a high consequence or could affect area, to my recollection.
Do you think the people of Erling care whether they're an HCA?
Again, that's important.
Would you be surprised to know that the city of Erling submitted an objection in these proceedings and asked that the pipeline route be moved?
What was the question?
Would you be surprised to learn that Erling also would like the route moved?
Okay.
You're not surprised?
I don't know what to think of that. So I haven't seen the objection.
City Council sent a letter into the board, and it's a direct exhibit of Mr. Willingham, one of the county's witnesses. But would you accept if I suggested it was less than a half a mile, and that they'd like to see it be farther away?
I guess that's an accurate statement. I don't know.
And so, I guess what I'm wondering is if you're willing to move it for Bismarck, why not Erling?
Well, as I've said many times in my conversation with Mr. Jorde this morning, siting is an exercise in identifying risk and being able to mitigate that risk.
But I'm really asking you about development and about priorities at the local level. And at that level, does it matter that they're a high consequence area? They'd like to develop east of Erling. What makes Erling different than Bismarck, other than size?
Well, I'm just saying that at this late stage in the project, it's very difficult to move the pipeline.
But not impossible.
It's very difficult to move the pipeline within this application, and I don't intend to amend this application.
But you're moving it in North Dakota.
We had some incentive to move it in North Dakota. Again, that had nothing to do with safety, had nothing to do with risk, in our opinion, or economic development. The pipeline was already outside of the economic development area.
And that brings us back to Charles City just for a moment. But that economic development project, that part of the community would like you to move it for economic development reasons. What makes them different than Bismarck?
Well, I think they'd like to sell us the property.
Well, they were here to testify, and that isn't what they said.
Well, he placed a value on the property, if I remember correctly. But again, it depends on the context of these conversations. So Floyd County, for instance, I mean, our team has met with Floyd County, as you know, well before you even engaged with Floyd County. And it was the Board of Supervisors in Floyd County weren't always receptive to working with my team. And so we proceeded with what we thought was the most prudent route through that area.
Does it matter to Summit if a company or a community welcomes natural gas but not carbon? Will you respect that community's wishes about what risks should be in the community for whatever those reasons are?
I mean, I have to try to respect everyone's wishes within reason.
And yet, still like to be in the industrial park in Charles City, correct?
Again, Mr. Whippel, if we'd had this conversation a year and a half ago,